Now, on the flip side of things, we said that there was these freehold estates that we just beat into the ground, and there were these non-freehold. Okay, non-freehold being leasehold or non of ownership. And so I'm not going to. Well, I don't need to go into the leasehold in detail. I'm going to teach them to you, but we are going to talk about the leasehold estates again later. But you will realize that you like these a lot better because it's just very straightforward. Okay, it is very, very straightforward for these leasehold estates compared to these freehold estates. So when we're dealing with leasehold estates, not of ownership, there are four. Now they do have a couple different names. There's what we call an estate for years, also sometimes referred to as an estate from year to year. We have a periodic tenancy, sometimes referred to as an estate from period to period. We have an estate at will, and we have an estate at sufferance. But this is where I'll warn you of something I said last week, okay? There are some things that are exactly what they sound like, and there are other things where the name is a little misleading. Case in point, folks, if we're talking about estates of lease, and I said an estate for years, how long would you assume this lease is for? Genesis, 10 years?
Did you say, I'm sorry, repeat the question?
Yeah,
Did you say how long is the estate for years for?
If it's, since it's called an estate for years, where does your brain go? How long do you think this lease probably is for?
Depends. It starts and ends.
A year and it's renewed each year?
Sometimes you just got to fall into the traps, folks. The point is, the word years makes you think years. Like, of course your brain does that. Some of you are like, well, I read ahead, so I'm not trying to fall into it. Listen, fall into the trap. There's a teaching point there. It sounds like it's for years because of the name estate for years. There is no specific time. Folks, this is what I'm trying to warn you of. Don't just assume because what it sounds like. An estate for years is very specific. All it is a lease with a very specific start date and end date. That's it. That is it. An estate for years has a very specific start date and end date. In other words, when it's done, it's done. Get out. And so this is the confusing piece. A 10-year commercial lease would be an estate for years because it will have a start date and it will have an end date 10 years from now. And if you want to stay there, you will be negotiating a brand new lease at that time. However, a 4-day beach vacation rental is also an estate for years. Why? When your 4 days are up, get the heck out. So don't think that it has to be for a long period of time. The biggest factor of an estate for years is when it's done, it's done. When your day is up, get out. Everybody with me? That's it. That's a lot more straightforward than the other ones, isn't it? You're like, I like this. Okay, so when it starts, it starts. When it's done, it's done. I like this. I can live with this. Yeah, it's kind of nice, right?
Called estate for time.
Say what?
Should have been called estate for time.
Well, if you were welcome to petition that, Raphael. Listen, I don't know how they came up with some of these names. I'm like, y'all really were just smoking crack when y'all named some of these things, didn't you? Because, like, it's confusing as all get out. But a lot of these terms have been around for a very long time. They've just kind of evolved with, things over the years, and we just haven't changed them. So sometimes it's old school. Now here's the big differentiation between that one and the next one. So periodic tenancy, also sometimes referred to as an estate from period to period, differs because they will automatically renew. That's the key difference. And so all residential leases in North Carolina start out as a periodic tenancy. If you are renting a property right now, whether you realize it or not, when you signed it, you signed a lease probably for 6 months, a year, 2 years as your initial term. And it always has some type of language in there that says something along the lines of, this lease will automatically renew for a subsequent year, 6 months, month to month, something like that, unless the tenant and or the landlord gives each other notice at least 30 or 60 days prior to the end of the lease. That is that automatic renewal. You see the difference there. An estate for years, when it's done, it's done. In a periodic tenancy, it will automatically renew if you do not give the requisite notice of your intent to not renew. That's it. Doesn't matter how it renews. It could be month to month, could be another 6 months, could be a year. The key piece is it will renew unless you give notice of your intent to not renew on either party. That's it. Jenna says, so it's kind of like the subscription of a gym? Yeah, typically. Or subscriptions to just about anything, right? Automatically going to renew unless you give notice at least a certain period of time. Very similar. So, an estate at will, just think with permission. Okay? That's it. Let me give you an example. I had a buddy of mine, one of my best friends, who is also in real estate. And we've been friends for a while. And in the midst of us being friends, he was going through a divorce. And of course, he was having to get that all worked out, and he was going to move out, and his ex was going to keep that house, and he was going to go buy another house as part of their whatever. And so in the midst of him trying to find a house, I said, oh, hey, man, listen, I got the room. Come stay at my place as long as you need to until you close on your house. Folks, that's an estate at will. It is with permission. It is typically not associated with time. It is typically not associated with money. Stay here until you get back on your feet. Stay here as long as you like. Stay here until you close on your house. Stay here until whatever. That's all an estate at will is. With permission. Typically not accompanied with time. Typically not accompanied with money. With permission. And then the last one is an estate at sufferance. And as you can see, that word sufferance doesn't sound pretty. So an estate at sufferance is basically some type of tenancy where the tenant gained access to the property in one of these other three ways, probably initially, legally, but when their time was up, they didn't leave. I just saw your question. Can it be verbal or does it have to be in writing? Typically verbal. There's no rule stating that it can't be in writing. The problem with that question is you will find out that later contracts have to have some type of consideration to be valid. And since this really has no consideration, then putting it on paper wouldn't really matter. So I wouldn't get too caught up on that. Yeah. So an estate at sufferance is you probably gain access. It's not breaking and entering, right? It's not trespassing. But let's go back to the estate for years example. If you sign a 1 week rental at a beach house, and your checkout time is 11 a.m. on Sunday, and you're still there at 5 o'clock on Sunday, you're in a state at sufferance. You were supposed to be out already. If you sign a 10-year commercial lease, and on the day that you're supposed to be gone, you're not gone, you're in a state at sufferance. Same thing with a periodic tenancy. If you're renting an apartment for a year, and you were supposed to give 30-day notice, and you say, okay, here's my 30-day notice, I'm not going to renew my lease. And so this is your last day now, and the day after you're still there, you're in a state at sufferance. If you have an estate at will, stay here as long as you like, and that turns into 6 months, and somebody looks at you and says, okay, it's been long enough, get the heck out, right? That'd be an estate at sufferance. Genesis says, can it be like when people are in the process of an eviction? Yes, it absolutely can. They would be in a state at sufferance during that time, and that is one of the triggers to allow you to evict people because they're not supposed to be there anymore for many different reasons. So that's all an estate at sufferance is. Your time is up and you didn't leave. What you got, Tara?
Would it be when they break any part of the contract that they turn into a state at sufferance?
The thing is, when they break part of the contract, that is called a breach. And the breach typically gives you the right to remove them or to terminate their lease early. And they wouldn't necessarily automatically be in a state at sufferance yet because you have to go through the proper channels. And state at sufferance means you were supposed to be gone already and you're not. When you're evicting somebody, sometimes they're not required to be gone until the eviction is finalized. Does that make sense? So they could be in breach, but still not be in a state in sufferance yet until the magistrate kicks them out. It's one of those things, right? Yeah. That's it. Now, these are going to come back up in the landlord-tenant section way down the road, and I mean way down the road, so you'll probably forget this by the time we get there. But they're a little more straightforward than the freehold estates, to say the least. Now, let me give you a couple honorable mentions here while we're talking about estates. You know, they're not going to be nearly as testable, and they're not as, in-depth. And I think I kind of mentioned this last week, and if I didn't, whatever, my brain sometimes. The first one is called a marital life estate. And what it basically is stating that you cannot disinherit your spouse, okay? In North Carolina, anyway, you definitely can't. And so what that means is, let's say that you own stuff, right, and you're married, and you die, and your will tries to leave your spouse out of getting any of the things that you owned married together. You can't do that. Okay, you are not allowed to disinherit your spouse. However, they will do what's called an elective share and utilizes what's called the length of marriage approach. So let's say that you try to leave everything you own to your kids, but you were married. The government's going to say, well, no, you can't do that. Let's take a look at how long this person was married to this other person and decide what portion they're entitled to. Okay, that's it. It's not an estate per se, but it's basically stating you can't disinherit your spouse. They would get something. Now, of course, that would not be the case if you had what's called a prenuptial agreement. You could leave whatever was negotiated. If you're not familiar with that dialect there, prenuptials mean let's identify the things that I owned before we got married and what you owned before you got married, and those will not be part of our merger. You know what they say, right? In marriages, what's mine is yours, and what's yours is mine. Of course, some people play it as what's mine is mine, and what's yours is mine, okay? But listen, whatever. It is what it is. Now, the other one on this list is a homestead. Folks, listen, in 2024, if you're on social media in any way, shape, or form, I'm pretty sure homestead means I have chickens and bake sourdough bread. That's the conclusion I've come to in 2024. However, that hit close to home, Brooks? A little bit? It's funny, Brooks. Listen, man, I got 82 acres and talk about getting cows all the time, okay? I'm one step away from being a hippie. No, not really, but you know what I'm saying. Yeah, it's all right, Brooks. Listen, I kid. Folks, the difference is, I just saw Brooks' face. He's like, it was a joke, Brooks. Don't take it seriously, okay? It's a joke. Homestead exemptions from a real estate point of view are not anything like homesteading in the real world, which of course is a lot more complex. Like I said, it really was just a joke. A homestead exemption is basically additional protections for your primary residence, where certain creditors, okay, not all, but certain creditors like American Express or MasterCard or, people like that would not be able to go after your house for debts that you owe them. Of course, the bank that you borrowed the money from to buy your house could go after your house. That's all it is. A homestead is basically additional protections from creditors attempting to force you to sell your house and be homeless in order to pay debts. That's all it is. Now, of course, there are other ramifications too of outside of this real estate class. Some municipalities, some states, some whatever will have homestead tax exemptions where if you meet certain criteria, you pay different tax rates. Also, some of them will have, tax exemptions for people of certain ages. That's all it is. Homestead is just, it's literally additional protections for your primary residence. That's all it is. So here's where we're going to get into a very similar concept, and it's going to be similar test questions, but not the same thing as the estates. When we were talking about the estates, folks, we were talking about what level of interest or relationship you have to the property. Well, now we're switching gears and we're talking about how many people have a relationship to this property. Okay, very different concept here. And so when there is one owner of a property, we call that ownership in severalty. And that kind of goes back to that same word we use when we're talking about fixtures, right? Like severance. Think of the root word to sever or to be standing alone, not the word several, because that'll confuse you if you think several. Ownership in severalty is one owner. If Chelsea owns a property in Chelsea's name only, that is ownership in severalty. And this would be true of a business too. If Microsoft owns a property, that is ownership in severalty. Microsoft is the sole owner. Ownership in severalty, folks, it's neat, it's easy, it's clean. Why? That one owner decides that they want to sell. That one owner decides that they want to paint it. That one owner decides that they want to lease it. That one owner decides everything about the property. It's easy because only one person is making the decision. Well, there is also what we call concurrent ownership. Concurrent ownership is more than one owner. Could be 2, could be 20, could be 500. Doesn't matter. Okay, concurrent ownership means more than one owner. Why is this an important conversation to have? Well, folks, if more than one person owns it, that means you need more than one person to agree that we're going to sell it. More than one person to agree that we're going to lease it. More than one person to agree to paint it. More than one person to agree to do this, that, or the other. Now, just like I did with the other chart, obviously there's not as many pieces here. I'm just going to go ahead and give you a small breakdown of each. Okay, we're just going to separate them out. I'm going to give you a small breakdown of each, and then I'm going to, of course, give you the slides that kind of go along with them. So let me do this. Let me just block out this first, okay? Let's start with this first one. And this is where I told you, don't get so caught up on the word tenant. Because here it is, we're talking about owners, but we're calling them tenants in common, or in other words, tenancy in common. There's that tenant word again. Still means owners. It's fine. Don't panic. So tenancy in common is one of the most common forms of concurrent ownership, meaning multiple owners. And what's unique about this, and this is where I'll give you an example, folks. What's unique about this is if you own a property, number one, it doesn't have to be equal shares, but it could be. And let's say that 4 people own a property together, and we say they each own 25% of that property. The most testable aspect of tenancy in common is you can will your interest. So if you own 25% of a property and you die, you can leave that 25% to someone else. That is a key piece of tenancy in common, or tenants in common. And so let me kind of give you a real world example of this, folks. The property that I referred to, and I always like to use it as an example because it hits home. I kind of can explain it a little bit better because I've been there, done that. So the property that I have down in Georgia on the 82 acres was actually, once upon a time, my grandparents. And when my grandmother passed away, it was left to me, my brothers, and my cousins. There was 8 owners on this property as tenants in common. And when you've got tenants in common, things are a little bit messy, to say the least, because you've got 8 people that all have to come together to make decisions. Well, folks, it's like herding cats. It doesn't really work too well. So when you're dealing with people having 1/8, if any of those people died, they could leave their 1/8 to their next of kin, or they could sell it off, they could do whatever. Now, I want to point out something interesting before I take this a little bit further. Even though I'm saying 1/8 interest in this property, I'm also going to tell you that this interest is undivided. So, Bree, this is answering your question right now. Bree said, is this equivalent to a timeshare? The answer is no, and here's why. This interest is undivided. What do you think I mean? I just told you there's 8 owners. What do you think I mean when I say it's undivided?
Like the land is not divvied up into 8 pieces. Is that what you mean?
That's exactly what I mean. Folks, undivided, and it's not equal, but undivided means the land is not divvied up. So here's what actually happened with this property for a period of time, folks. I ended up buying out all of my cousins, and so for a period of time, I owned 5/8 of the, 6/8 of the property now. And now my brothers each, I let them keep their 1/8 for a period of time, and they each had 1/8 interest in the property. So let's use that example. 3 owners, 1/8, 1/8, 6/8, which 75% and 12.5%, 12.5%. What that means is, to Cheyenne's point, I can't draw a line and say, well, my brothers can only use 1/8 of the toilet, or 1/8 of the hallway, or 1/8 of the pond, or 1/8. You see what I'm saying? When I say undivided, it means they all have equal access to use it in its entirety because they are owners. So let's keep going with this thought of tenancy in common. And so I gave you this example, and you know, I'm kind of like showing you how it doesn't have to be equal, and giving you a real world example of, you know, 75%, 12.5%, 12.5%. And I left out saying, well, it's also undivided, even though it kind of sounds funny, because I'm telling you, the ownership percentages is different, but what's undivided is the actual use. Folks, imagine, and this is the dangerous thing about concurrent ownership. Imagine that at the time that was the structure of that property, if one of my brothers moved into that house, I couldn't do anything about it. Can you imagine, like, trying to call the cops and be like, well, you know, officer, I need you to remove this owner of this property. You see what I'm saying? Doesn't make a whole lot of sense, does it? And so you got to be very careful who you own property with, because they are an owner. When it comes down to it, when we're dealing with the 1/8, this, you know, 12.5%, 70, it doesn't matter. The only thing that matters from that numerically is if that was the structure, one person's responsible for 75% of the tax bill, 75% of the insurance bill, 75% of whatever. The other person's 12.5. And when it comes to the proceeds, if you sell it, then one person would get 75% of the profits, the next person would get 12.5% of the profits, so on and so forth. But they're all owners while they maintain the property. And so the other piece is the willable aspect. And I think that's a decent enough explanation. I'll get into a little bit more in just a second when I actually give you the slide. I'm just kind of walking you through them in a nutshell. What you got, Raphael?
Just a quick question. Let's say a property is owned between three people. Okay. They're related, but they're not like husband and wife. It's like, you know, cousins, like three cousins. And one of the parties wants to sell their share, their third. What is the I would say how does it work? They have all to agree in order for it to be done, or they have to buy their, you know, the other person out? How does it work?
Yet again, the best answer is depends, but just to give you an answer, when you own it, you own it. You really can't stop somebody else from selling their 1/3 to whoever. Now, think about that, Raphael. If I approached you and I said, would you like to buy a 1/8 interest in a random property in Georgia that you've never been to, and you will own it with my brothers who you have never met? Or in me, I mean, are you interested in buying that? Well, I suppose it depends. The answer for most people is no, but there are other legal concepts like right of first refusal and right of first opportunity to purchase, we'll talk about later, where you could structure it where they had to sell it to one of the other owners first before they could sell it to somebody else. But that's not the default. It would have to be done up legally, and if it wasn't, that's where people have a tendency to fight. And there's one other option. As you might imagine, when multiple people own these properties and they can't all come to a consensus, the only thing you can do sometimes is take each other to court. And it is what it's called a partition suit, or in other words, a petition to partition, where if y'all can't agree on things, you can go to the government and or a judge, and they will basically break it into what they deem 3 equal pieces and say, this is your 1/3, this is your 1/3, this is your 1/3, and it is what it is. But of course, you know, it's kind of like that. Well, I won't go that route, but sometimes the lesser of two evils in order to maintain the value is to come to an agreement versus everybody getting some weird third chunk that is no longer as valuable, because you're all going to lose money if you can't agree. So there's no one size fits all there. I mean, there's a lot of different things that could come into play.
No, I was just wondering because there was an occasion where I have a third of it. I've asked to sell it, but nothing kind of happened. You know, it's still like up in the air, and it's been going on for over 6 months. So I'm not quite, and I just don't want to feel. You know, I just don't want to spend money with lawyers and stuff. So I don't know what would be like the legal action in terms of.
Well, you the double-edged sword. Raphael, you just said the legal action. The legal action involves lawyers. So unless you can be magnanimous and the diplomat and talk everybody into doing it, your really only action is lawyers.
Gotcha.
Yeah.
Thanks.
Yeah, for sure. What you got, Sinful?
Well, actually, I'm not sure I clear. So when you were saying tendency in common, you have 85 acres property land. You have, let's for example, you are eight or 10 brothers, whatever. So they have equal rights, right? So let's in that 85 acres you have 5-bedroom property, 5-bedroom house. How they will be divided?
They're not divided.
You guys will use.
That's the key piece. They're not divided, right? That's why I'm saying undivided interest. And so there is a house on the property, and at the time that my brothers each own 1/8, there would be nothing I could do to stop them from going and coming as they please. And that's why you have to understand this when you own property with other people. They are owners. Now, it wouldn't necessarily make sense for you to own a 5-bedroom house with multi-families living in it without some clear defined arrangement as to what that looks like. But this is a vacation home for me, and so it's just like a come and go thing, right? Yes, and so, you can clearly, you could do a fractional form of ownership, and this is why, excuse me, a second ago when somebody's like, well, is this like a timeshare? No, timeshares are what we call fractional ownership. You only own your time frame to go. You cannot enter that property any other time except for your week, your month, your whatever. So there's legal arrangements where you could structure it where this is a dedicated bedroom or this person gets 600 square feet. You could always do that. But what we're saying is default with concurrent owners. If you didn't clarify this, they are all owners and they can all come and go as they please. Is that everybody with me? So let me introduce the next one. And as I said, I'm just kind of introducing it. There are slides for each, but I just wanted you to kind of see the difference. So joint tenancy, and let me backtrack too. When I said tenancy in common, it's for anybody, folks. Anybody can have tenancy in common. You do not have to have a relationship like cousins or brothers. For example, with tenancy in common, every single one of us could go out right now, all 32, 31 of us, however many there are. If we decided that we unanimously wanted to buy a beach house, we could buy a beach house together, all put in money, and each own 1/32 of a beach house. There is no relationship specific needed to be tenancy in common, and every single one of us could will our share. So much like tenancy in common, joint tenancy is for anybody. You do not have to have a special relationship with anybody to get joint tenancy. You could be nobodies, you could be acquaintances, you could be, siblings, you could be, whatever. There's no special relationship. The big difference between tenancy in common and joint tenancy, the big difference. I go for a couple days without teaching y'all, and I'm talking for 14 hours a day. The big difference is joint tenancy has this very unique thing called a right of survivorship. And so in this, let me give you an example. In a joint tenancy relationship, let's say, just for convenience, for easiness of explaining this, there were 4 owners. Person A, person B, person C, and person D. And they each had a 25% interest in the property. When I say right of survivorship, what I mean is, kind of going back to the similar things I just taught you, you cannot will your ownership. Right of survivorship means your other joint tenants will absorb your share. And so if person D dies, even if they have a will that says, well, I want my 25% share to go to my kid, it will be ignored just like a conventional life estate would have been ignored. And what's going to happen is these people are going to absorb that 25%, and they will all be, what is it, like 33.75? I don't remember, like 75% divided by, 100% divided by 3. 33.333 repeating. That's what it would be.
Yes, 33.3.
I had to think about it for a second. Thank you, Sergeant. I'm like, no. I'm trying to break up the 75% into twos. So yeah, it would be now instead of 25% owners, 33.33 repeating, which is basically, 1/3 of 100. And so when this person dies, these two would share 100%, so they would become 50-50 owners. And when this person dies, this person would become the 100% owner. That is what joint tenancy does. You cannot will your share. The other joint tenants absorb it as somebody keels off. Now, at this point, person A is an owner in severalty. And if they wanted to will it to their kids, they absolutely could. Because there are no other joint tenants. Everybody with me? I'm going to go into this a little more in depth in just a second. Bree says, so both of them have the right of survivorship or no, because they are all full owners. And the tenancy in common does not have the right of survivorship. You can will your tenancy in common. Joint tenancy has this right of survivorship. And as one person dies, the next person absorbs their share. Or the rest of the people absorb their share. You cannot will it. Cannot will it. Cannot will it. Folks, here's the easiest way to remember this, even before I teach it to you fully in depth. Okay, look at this word right here. If any of you are familiar with the devil's lettuce, okay, sometimes people smoke joints. Okay, and listen, you cannot, you should not pass a joint to your kids. And much like you can't pass a joint to your kids, you can't pass this joint tenancy on to your kids. There you go. You cannot will it. Can't do it. What was wrong with that one, Brooks? He's like, my 7-year-old smokes reefer all the time. Like, what are you talking about, Sam?
First of all, I don't have any kids yet, but if I were, okay, so say it's a younger cousin, what better safe space?
I get it. I get it. I'm just trying to, yeah, I get it. But, I mean, I wouldn't give my own kids, I'd give my brother's kids some, right? I'm not going to go to my own kids, you know? I'm the cool uncle. I'm not the cool dad.
I'm definitely not going to be that cool at all.
Right.
I'm just saying.
Right. I get it.
I'm just saying.
I get it. Yep, that's fair. But I'm just trying to give you a mnemonic to help y'all remember it on the test. That's fair. That's fair.
I
That's
have
fair.
a question.
Um,
Is your name James or Brooks? What?
He goes by Brooks. I'm not crazy, Genesis. I mean, I am, but he said on day one he goes by Brooks. I'm not crazy. I just remembered it. So his legal name is James. His nickname is Brooks.
It's part of my middle name. My mama made it confusing as hell. Blame her.
There you go. Don't you listen? Parents are good for that. I get it.
Amen.
Yep. Mm-hmm.
So I have a question.
Yeah.
Just to make sure I understand this, the tenants in common have to be any type of relationship, like cousins, brothers.
You do not have to have any special relationship with either of these.
The tenants in common.
Neither.
Okay.
Yeah. We could all buy a property, folks. Listen, 31 of us in this room, we could go out and buy a property together, 31 1/31st owners as tenants in common. Sure, we could. We could also go out and buy a property today together as tenants in or tenants by joint tenancy. I'm sorry, joint tenancy. You do not have to have a special relationship with the person. Anybody can do this. Either or. Tenants in common and tenancy by the entirety. Everybody with me? Now, I'm going to take them a step further in just a second. I'm just giving you kind of a quick rundown here. And the last one, before we get into them in a little more in-depth, just because sometimes when there's like notes on the screen, I told you, some people get so caught up with writing like notes that they don't just kind of listen to the words, and I've realized that over the years. So here's where things change a little bit. Tenancy by the entirety is for married couples only. Meaning you have to be legally married at the time that you take title to the property to have tenants by the entirety. Well, folks, that being said, this is one that we could not do, right? You cannot have 31 people married together and go out, right? That's not going to happen. So this is only for married couples. Now, please understand, if you buy a property right now by yourself, that's called ownership in severalty. And if you get married later, that is not going to turn into tenancy by the entirety. That's what we call a marital interest. We're going to talk about that in a second. But you have to be legally married at the time that you take title to the property. It's called tenancy by the entirety. Now, just like joint tenancy, this also has a right of survivorship. What do I mean? Husband and wife, 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 husband, husband. We don't judge, okay? Whoever buys the property, who owns it as tenancy by the entirety, if one spouse dies, the other spouse owns all of it. It is automatically equal shares. It is automatic right of survivorship, and it is non-severable. You cannot sever your half off and sell it to somebody else. The only way for this to end is death, divorce, mutual agreement.
But even if it's divorce in the state of North Carolina, it would be an equitable division of the courts, correct?
Yeah, typically. Basically, you can't, if you're divorcing in North Carolina, you're not legally supposed to leave the deed this way. And so somebody would have to be removed and be an equitable division under most circumstances, unless your divorce decree said otherwise. People could agree to give somebody the entire house. People could agree to change it as to tenants in common and sell it. There's a lot of things they can do. Brad says, does it skip probate? Yeah. So, for example, let me give you an example test question here. Husband and wife purchased a property in 2011, and the husband dies in 2022. In his will, he leaves the house to his firstborn son, who owns the property. His wife. Probate will ignore that will that states he wants to leave the house to his kid, because when he died, his wife became 100% owner. Owner in severalty. Does that make sense? So let me give you the slides. Somebody had their hand up. Did you still have a question, or did you put it down because you're good now?
I kind of, not really. Okay, I've never been a part of a home buying process, so I'm sorry if this is stupid.
No.
But all of these, like the ownership types, the estate types, all of this is set up when someone buys a house and sets up the deed, or is it like up
Yeah.
to the buyer to take upon themselves to do all of it?
There are defaults, but understand that you would have a conversation with an attorney as to why you may want to do one over the other. And understand that we as real estate brokers that you folks are aspiring to be, we're not able to give legal advice. I would never tell my clients which one they should do. I would tell them that there are options, and if they're interested, they should consult with their attorney on how they want to take title to the property. But it is determined by the buyer and their attorney at the time they buy the property. It's their call.
And they can change it later? Or
Absolutely, they can.
okay.
Yeah, absolutely they can. But understand that you can only change it with mutual agreement yet again. So if you put somebody on there and you decide you want them off and they're tenants by the entirety, or, and you're married, not going to happen. You're going to need attorneys. Going back to Raphael's thing, right? Depends. What you got, Tara?
If somebody buys the property and they're not married, then they get married, and then the person dies, would it be in a tenancy by the entirety?
No, it's never going to be tenancy by the entirety. So in your scenario, you said somebody buys the property and then they get married. Okay, well, that means that if you didn't have a prenuptial agreement, you own this property in severalty. Legally, on the deed, you still own it in severalty. But when you got married without a prenuptial agreement, this person has a marital interest in your property. So who died, the owner or the spouse in your scenario? The owner. Here's the thing. It's really going to depend on a lot of pieces, because I told you, you're not allowed to disinherit your spouse. So number one, imagine that you had a will and you tried to leave that home to somebody else. That somebody else will probably get it, but your spouse will get that elective share based on that length of marriage approach, because they didn't own it as tenancy by the entirety. However, imagine that you die without a will. I told you the number one person under the law of intestate succession is your spouse. And so they will get it if you die without a will. Yeah. Now, are those specifics testable? No, but... What you got, Sergio?
So, like, I was looking at some stuff like that because I do own a few properties, and I am married, of course. But some of those are like family properties where me and my sister are only two that own them. Now, just say I have those two properties and I purchased another one with my spouse. Now, what if I put all of that into a trust? How does that go about? Or do they still get rights to that? not looking to do anything to somebody to cut them out, but they say if I want to buy properties and I want to leave them to children.
You can't put anything in a trust that has concurrent owners without all parties agreeing. And trusts are so oddly specific. Like, that's all attorney stuff. I mean, it's really going to depend. I mean, you got to understand, like, this stuff is all exceptionally fascinating. And I'm sure, you know, I mean, everybody kind of has, like, some connection to something like, oh, my cousin's uncle did this, my grandma. And I can't answer, you know, this is too oddly specific because it's really going to depend on who owns it, how they own it. You know, are all parties agreeing? What do you want that trust to do? And folks, that's why attorneys make the big bucks, because it gets very confusing at the end of the day. Can you put stuff in a trust? Absolutely. But there's also things like alienation clauses, and if you've got financing on them, those are going to be considerations as well. So, yeah, it gets complicated. So, go ahead.
What was the other thing you said about tenancy by the entities? The entirety.
Uh-huh.
It was unseverable and then
Automatic right of survivorship, automatically equal shares, non-severable. Okay, you can only end it by death, divorce, and mutual agreement. And as I said, I'm going to give you slides for these folks. Let's go and dump into it. As you're kind of getting this, the reason why this is so important is because if there's more than one owner, the question is who has to agree to sell it? Typically everybody. Does everybody have the same percentage of ownership? Who can use the property? And most of these, all of these, are undivided interest. And so that's where they can all use it. It's not something that is well advised for you to own property with other people unless you really know, like, and trust those people. Because it can get really muddy real quick. When people don't agree, it gets nasty. And the only thing you can do when people don't agree is attorneys. So here's the slide for tenants in common. Remember, okay, I'm going to remind you, tenants in common is the most common. It is for anybody. You do not need a special relationship. Could be equal shares, could be unequal shares. You can sell your share, you can will your share, you can do whatever. Now, back to what I said earlier, could you put a separate thing in there that says if you sell your share, you have to offer it to the other tenants in common first? Sure. That's a special thing. Otherwise, people can sell their shares. So there is no survivorship. So if you own property as tenants in common and you all own 25% and you die and you say, I want my 25% to go to my kids. Let's say you got 2 kids. They will split that 25% in half. So they will each have half of 25%. So key piece of tenants in common can be willed, can be willed, can be willed. So let me give you a visual here. If somebody owns a property, let's say is 60-40, and the 60% owner dies, and in that, just like in that example I just gave, they leave their 60% ownership to their 2 kids. Their kids will now own 30%, 30%. And so you can never have more than 100% ownership, and now there will be 3 tenants in common. Kid 1, kid 2, and the other tenant in common that's still alive. Can be willed. But I'm feeling pretty comfortable with the tenants in common. For anybody, doesn't have to be equal shares, can be willed. But it's still undivided, which means everybody can use the property, and you can't stop that.
Sorry to interrupt. Seth, you said like last slide, when you have the equal percentage of the share for the tenancy in common or something, right? For example, you 25, 4 people, each individual have 25%, right? The one person died, the remaining 25% will go to remaining.
That was joint tenancy, not tenancy in common, right? The one where you're going to absorb somebody's share, that's joint tenancy.
Joint tenancy, okay.
Yeah, we're about to get into that one.
So this is a separate individual, right? Or when you say tenants, 2 people, that's a separate individual, not married couple.
Yeah, no, this is not for a married couple. It doesn't matter, right? Cynthia, you and I could buy a property today together if we wanted to as tenants in common. You could have a relationship with them, you could not, doesn't matter. Yeah. Genesis, are you talking about the people who inherited the property here? Is that who you're talking about? Has it say so? Yeah, of course. They're owners. They would now be able to come and go freely as they want. Yeah, absolutely. They have a say so. Yeah.
No, I meant like if the other person doesn't want the new person to have ownership, can they be like, no, like I don't want to? Can they oppose to it?
No. No. Because that's their ownership to own. Now, once again, could you put that in a legal arrangement from the word go? Sure, but without agreement to the contrary, they can sell it, they can will it, they can do whatever. It is what it is. Which is why I will stress again, make sure that you know, like, and trust the person that you buy property with, because it can get very messy very quick.